So there's a number of changes at age 18 that are important to be aware of. Some, and we'll talk about those that might happen a little before as well as after, but 18 is really an important trigger for a number of things to be thinking about. So first, let's talk a little bit about what happens with special education. On your slide, you see the words IDEA, Individuals with Disabilities Education Act. This is the law, the federal law that governs special education, and it requires that transition planning begins starting actually at age 16 in the federal law and age 14 in Wisconsin. What this means is that you begin to have conversations about, for example, what the trajectory of classes might be depending on what that young adult might be interested in doing in the future. And that should start at age 14. But there might not be a lot going on at age 14. Certainly as young adults turn 16, there should really be some thoughtful conversations that begin to talk about what are you thinking about for the future. Something really important to know is that students enrolled in special education do not exit school at age 18. They can stay enrolled until age 20, through their 21st birthday, or through the year that they turn 21. So if you're interested and want to be thinking about how to, for example, begin to explore employment and what that might look like, that can happen between 18 and 21. So young adults typically would be participating in the regular ed curriculum through their 12th grade with their peers. If there is additional academics that they want to be doing, that can continue. But ideally, we should be thinking about 18 to 21 really being focused on the kinds of skills that young adults are going to need and opportunities to explore what they might be doing after high school. And that continues through their 21st birthday. If a young adult graduates, then they no longer have access to the supports through IDEA. Now, a young adult can walk across the stage and participate in graduation, but as long as that diploma isn't finalized and official, they can continue to still participate in special education supports. Something else to be thinking about, and we'll talk a little more about this in detail as we go along, something else to be thinking about is connecting with an Aging and Disability Resource Center. So these are centers throughout in every county in Wisconsin who can help provide information about what adult supports, long-term supports might look like, what employment supports might look like. And it's an excellent resource available to you in every county in Wisconsin. The Aging Disability Resource Centers are also the entree to adult long-term supports. And that can look different in different counties, and we'll talk more about that in a minute. Aging Disability Resource Centers can start serving young adults when they are 17 years, 6 months. So for example, if you wanted to have an Aging Disability Resource Center participate in an IEP meeting, they might be able to do that as long as the young adult is over 17 and a half. Something else to be thinking about is Social Security income. So if a young adult is eligible for Social Security income prior to the age of 18, then it's possible they may also be eligible after the age of 18. If young adults haven't been eligible because of family income, that will also change at age 18. So at age 18, family income is no longer considered as part of eligibility for Social Security income. That application can be made just prior to the young adult's 18th birthday. With Social Security income then comes both eligibility for Medicaid as well as a cash stipend that can assist with many of the things that an adult might need to support their lifestyle. Other things to be thinking about, there are significant changes in access to health information and in the ability for families to participate in discussions with health professionals. Called, you may have heard the term HIPAA, Health Information and Accountability Act, which governs access to health information. And what this says, beginning at age 14, access to some information by parents and other family members could be limited, so specifically reproductive health and mental health information. And then beginning at age 18, the doctor can no longer share information with parents unless some specific actions are taken. This is really important and something to definitely take steps so that you have things in place. So for example, if a young adult was in an accident when they were 18 years and 1 day and had to go to the emergency room, for example, the physicians could no longer share any information with parents about the status of that young adult unless certain things are done. And those things are either a power of attorney for health care and or a release of information with a healthcare provider. So if you have a conversation with your young adult and they are still interested in parents being involved and supporting them related to their health care, then they can sign a release of information that has to be done with each doctor to say you can share information with my parents and talk with them about my health care. And then a power of attorney also creates a more legal document that allows that to happen. So very, very important to do some planning related to healthcare prior to age 18 so that everybody knows what you want to happen. Similarly, if you're considering a hospitalization for families who have always been very involved with their kids who may have had a lot of hospitalizations, doctors can no longer talk with you while your kid is hospitalized unless that permission is given ahead of time. There are also changes related to healthcare coverage. So be aware that if a family has family coverage through, for example, Badger Care, that coverage will end for the young adult as they approach their 19th birthday, and is no longer considered part of the family unit, so that the number of family members goes down, which also changes the income eligibility for the family. So be aware that there can be coverage changes at age 18 in Badger Care. In private insurance, recently, as part of the Affordable Care Act, sometimes called Obamacare, young adults can now be covered under their family's private insurance up to age 26. That was not the case prior to the Affordable Care Act. Some other things to be thinking about are called advanced directives. So what is that young adult's wishes related to their care? Should they no longer be able to voice an opinion about what happens? And if there was a sort of a catastrophic injury or illness, what kind of intervention do they want their family members to advocate for on their behalf? Advanced directives is something we all should be doing for all of our family members. This is not unique to young adults with disabilities, but because the decision-making process changes at age 18, these are conversations that you might want to have. I did this with my son, and I actually had no idea what his wishes were prior to this conversation. And he made it known that he wanted any and all interventions on his behalf should he be incapacitated or injured and unable to act on his own behalf. So that was really important for me to know. Now I'm really clear what to do should he not be able to voice opinions about his own health care. And then lastly, are thinking about assisted decision making and the different strategies available related to assisted decision making. So you may have heard the terminology guardianship and powers of attorney. That's what we're going to talk a little bit more about right now. So when a young adult turns 18, called the age of majority, they are legally responsible for their decisions unless something happens. So that young adult can enter into contracts, can vote, can enlist in the military, can sign leases, have a bank account, all those things under their own control without parent involvement unless a discussion takes place and alternatives or support to that decision-making process is put in place. So for example, guardianship is a term that you might have heard. There can be both full or partial guardianship. Guardianship is a process that involves the courts where the court has to make a decision about that young adult's competency or lack of competency to make decisions. Guardianship can be temporary or permanent, but it puts all the decision-making authority in somebody else's hands. So, and then you can also have guardianship of the person or of the estate. Guardianship of the person has someone designated to make decisions for the individual with disabilities. Guardianship of the estate can be where the guardian makes decisions about financial matters and property, for example. A less restrictive decision-making opportunity is called powers of attorney. It's an alternative to guardianship. So if, for example, that young adult might need help making decisions about finances, you can have a power of attorney for finances. We talked already a little bit about power of attorney for health care. So this is a way to provide assistance with decision-making that still leaves the locus of control and competency with that young adult, unless circumstances exist where they cannot be making those decisions. And then there are also vehicles that allow for financial savings. In the vehicle is something called special needs trusts or supplemental trusts. In order to use these vehicles for financial savings, the young adult cannot have direct access to the money in those trusts and cannot make decisions, but has to do those through an intermediary. But it's a way to save for that young adult's future and still maintain access to benefits such as Medicaid. So again, this is a very brief overview just to tickle your interest about things you might want to be thinking about. And again, there are a large number of additional resources if any of these are of interest to you. So for example, we talked a little bit about powers of attorney. There is a form online through the Department of Health Services website that has been designed for this purpose, and you can download it and use it. You don't have to necessarily engage an attorney to help you do that process. Everything you need to know and the language you need to know is on that form.